I am Ann Hadley Griffin, and I'm one of your Associate Justices this year. Today, I will be explaining how to go about writing your brief. So the very first part about writing your brief is you need to divide the work. So for each side of the case, there is a petitioner and there is a respondent. You and your partner or partners need to decide who will be representing each side. When you present the cases, you present them together, but you need to have 2 briefs for each case. And so in total, you will have 4 briefs for the 2 cases. So once you've figured out which side of the case you will be writing your brief on, you need to go through the case and the case law and highlight or mark, I don't know how you want to do it, important information that supports your side of the case and that you can use in your brief. Now, when it comes to setting up your brief, we have a template right here. This will also be on the YAG website with all of the other Court of Appeals material if you need it. And this is just the brief template. And so I'm just going to go through it and so the cover page, you need to have the name of both you and your partner, your school's name, and the name of the case at hand. You will then, if you wish, add a table of contents. This is totally optional. You do not have to have this. I personally like to have it, but again, it's totally optional. After that, you need to establish your goal. And you will do this by saying, our goal is to prove. And after that follows what you intend to prove and the burden that you have to overcome and or any burdens that the other side is restricted by. You will then state the legal issue or issues at hand. After that, you will include a statement of facts. This can be copy and pasted if you wish, but it should be fairly short. You will not have to read them out at conference, but this is really nice to have to look back on. Then you will introduce and include any important amendments, statutes, or cases. So there are 2 or mainly 2, but sometimes 1 argument, depending on how many legal issues are at hand. For example, argument 1 addresses legal issue 1. And argument 2 would address the legal issue 2. This is the main bulk of your argument, and this is where you will add in all of that case law and stuff that you have highlighted or marked, and this is where you can really just show us your strong suits. After you have finished all of your arguments, you will conclude by restating your introduction and discussing how you have reached your goal and summarize your strongest arguments. At the very end of your conclusion, you should either instruct the court to reverse the former court's decision if you are the petitioner, or uphold the former court's decision if you are the respondent. And then, if you please, you can cite all of your information. Again, this is totally optional. I hope that this has helped you all, and I cannot wait to see what briefs you end up writing.
In this video, we're going to discuss the best ways to organize your individual arguments as well as the best ways to attack the constitutional issue in question. So when you first start to write your brief, you're going to want to make sure that it is organized. Now, we do provide a template for your brief if you would choose to use it. And so we're going to focus on the argument section in this video. So you're going to want to start with a claim that is relevant to the constitutional issue that is in question. A claim is kind of like a thesis statement about your argument, but if it does not relate to the issue being presented, then it is not going to make any sense. You're going to want to make sure that the arguments you are presenting are relevant to what is being questioned. You're going to need evidence to back up your thesis statement, as well as explanations to tie your evidence together into a cohesive argument. So you're going to want to use case law that is provided to you in the case for your evidence. All of your case law should be able to support the argument you are trying to make. You don't want to have too little case law, but you also don't want the bulk of your argument to be case law. You want to use a good amount and explain how the case law pertains to your argument. When you are choosing case law to use, see if you can explain how it works into the argument in that section of your brief. Case law that is just thrown into your argument is only going to take away from how valid it is, and it will make it easier for the opposing side to prove it wrong. Now make sure that each paragraph or segment of your brief only references one argument. So as you can see, there is one bullet that has argument on it. So you can have argument number 1, and then you can have argument number 2, or however many arguments you choose to use. So when it says address the legal issues in order, it means if there are 2 questions, then you're only going to want to address one in each argument. So when you're using case law, think of it more as evidence trying to prove your point. Don't try and mix arguments, as that will only make it more confusing. So you're going to want to stick with the same question for argument 1 and the same question for argument 2. When you are finding case law, you're going to want to try and use them in arguments that you think are unique. So that unique arguments are going to help you stand out and also come from a different angle. You don't want to use an argument that isn't supported by any case law or an argument that you think is going to be commonly used. Find pieces of case law that are within case law. What I mean by this is go through the cases that are provided and find case law within that case. The cases that are provided are not just the ones that are being argued by attorneys in front of the justices. There are cases in the back that are used for case law, and you can find case law within that case. You want to make sure that the basis and reasoning for your arguments are organized and are pertinent to the constitutional issue in question.
Hey Yaggers, I'm Nicole Belcher and I'm one of your Associate Justices for the 2021 YAG season. Today I'm going to be teaching you a brief crash course of how to use case law. So first of all, what is case law? Case law is like precedent cases that have been decided prior to the case that we're arguing today. So these are going to be things that you're going to find within the case packet that we gave you. So you'll have 2 packets that contain various sets of case law that pertain specifically to the cases that we're arguing here in Court of Appeals. So instead of having y'all go out and find cases from the internet or searching previous Supreme Court decisions, we're instead going to be providing all the evidence that you need to win a successful case. So today I'm going to be looking at the cases that we're talking about in Court of Appeals, specifically Court of Appeals Case 1, Van Orden versus Perry. I'm looking at where you can find your case law, how to use case law, and properly defining it as evidence for strong arguments within Court of Appeals. So without further ado, let's get started. All right, guys, so here we're looking at our first case in Court of Appeals, which is Van Orden versus Perry. And so within this, we're going to be looking at where exactly the case law is and how we're able to use it. So first through our case, we're looking at the section which is right underneath the description of the issue here. So beneath the statement of facts, that's not where you're going to find your case law. And beneath the issue, we're looking at these various tests that are provided. So this is the test section that is used to determine the decision legitimacy. So looking at the decision that was previously made regarding this case, we can reference these to see if in fact the decision should stand on Van Orden versus Perry. So within this, we're going to be seeing some sections which give us a little bit of insight into why the decision was made. So all of this can be referenced as case law. So any of this that you decide to use within your case as evidence would go underneath your contention or your argument, and you would reference it simply by saying within Lemon versus Kurtzman, if you're referencing this section right here, or, following that, we could talk about Lynch versus Donnelly. And so all of these things are going to serve as evidence underneath your argument or your contention. And within this, we can simply quote a short section as long as we reference your case law. And this is going to help your justices decide how many times you use case law and how strong it is within your argument. Below this, within the case, you're going to look at the precedent section, which simply relates to the above test. So this is looking at, as we referenced earlier, the Lemon versus Kurtzman section. That's nothing new. That's just giving us a little bit more insight on what exactly that case was saying, which could help you make a stronger argument relating to it. So if we keep scrolling down in our case, we see the same thing, the Stone versus Graham, which was referenced above. Same thing with this following case here. And if we keep going within our case, here's where we really get to the super useful, important pieces of case law. This is where we see the Lemon versus Kurtzman case really expanded upon. So within this, we're going to see the syllabus, which is pretty much a thorough summary of what happened within this case to best use it as case law. So within this, you can look at how our case relates to the decision that was made here and either justify it or say that it needs to be appealed because of the decision that was made here. So if you keep scrolling down, we see every time that it says held, that's where it's really going to tell you what the decision is. So beyond the statement of facts, this is the really important part where you're going to need to look. And after the decision, you keep scrolling, we see more kind of explaining what the case is. And underneath this, we see anywhere that's italicized is really going to be key in looking for pieces of case law. So here we see the Rhode Island statute, which obviously is a piece of legislation that's going to help serve as evidence for you. And it keeps scrolling. We see something similar with the Pennsylvania statute. And as we continue, we learn something really valuable about finding case law within this really large packet of information. As I highlighted here, anywhere that we see italics and something that's, like Everson versus Board of Education or, someone versus someone else, that's going to be the most important thing you want to look for. That's your case law right there. So within this, we see the court upheld a state statute that reimbursed the parents of patriarchal school children for bus transportation expenses. So that's going to tell you what the decision was and why it's good evidence regarding the case that we're looking at presently. So that's kind of your case law within the larger case that can be used as evidence. So anytime that you want to cite case law, like I said earlier, you're just going to simply tell us the name of the case. So for example, Everson versus Board of Education, and let us know why it's good evidence for the point that you're trying to make. So as we keep continuing, anywhere, like I mentioned, that we see these italics, that's going to be a prime location for you to find evidence. And this continues throughout the entire case. So just be careful not to miss any valuable information. Like here we see it references Allen without giving us the full name of the case. So just make sure that you leaf through this really carefully, not to miss any important opportunities for a defense of your argument. And we keep going and see just similar things here. So that's your case law. It's simply evidence. And the best way to find it is just by looking for the italics and the name of a case. So it's not too complicated beyond that point. You're really just going to want to read through here and don't feel pressure to use every single piece of case law. So as we keep scrolling, we see more legislation. And of course, within that, we're going to see more italics, which reference different cases. We see Allen repeated many times because, of course, that's the one that we're looking at now. Just don't feel pressure to use all of them. The justices, of course, want to see you use a large number to show that you understand and can properly defend the case in Court of Appeals. But even better than that, we want to see that you properly apply it. So sometimes quality is better than quantity, and we really want to see you dig deep into explaining why this piece of case law that you found within this, 52-page document supports the argument that you're making. So each contention, I would recommend using around 3 pieces of case law to provide thorough support for the point that you're making within your case. So as we keep scrolling, we just see similar things, finding those pieces of italics. and really using them as proper evidence to make an argument. All right, guys, I hope that was a helpful brief introduction to case law. And if you have any further questions about how to properly apply case law, how to use it as evidence for your arguments, feel free to reach out to any of your justices, and we'd be happy to answer any questions that you have, or reaching out to other attorneys as well, as they are very familiar with case law if they've done YAG before. Happy case writing, and let us know if there's any way we can help.